They said it would start this week. A deal between the UK and France, named One In, One Out, meant that migrants arriving via small boats could be returned to France under certain conditions. But today, a judge stepped in and slapped a legal block on the first removal flight. A 25-year-old Eritrean asylum seeker, due to be sent back under this scheme, won a last-minute reprieve after claiming he is a victim of human trafficking. This is not just a story of one man. This is the beginning of a legal storm that could unravel Prime Minister Keir Starmer's flagship migration policy. And although the government says it will fight these vexatious last-minute claims, legal experts, human rights groups, and displaced people say the system itself forces these claims, not abuse of the system. What you're about to see is where law, policy, and human rights collide. The scene: a high court in London. Judge Clive Sheldon listens as lawyers argue whether the Home Secretary properly investigated the trafficking claim. The government insists the scheme with France demands speed, deterrence, closure. The asylum seeker argues he's never had a full chance to present evidence to be heard. Serious issue to be tried, the court acknowledges. The removal is delayed. Just like that, the first deportation under One In, One Out is blocked. Overnight headlines, sharp criticism, political tension. Interior Minister Shabana Mahmood lashes out. She calls these legal obstacles vexatious last-minute claims, saying they undermine both the legal system and Britain's generosity. She insists that the government will challenge every such attempt. To her, law shouldn't be a loophole. To critics, it's a lifeline. And in the middle stands the asylum seeker, vulnerable, uncertain, but legally protected for now. For years, successive UK governments, Conservative and now Labour, have been under pressure to control channel crossings. Over 30,000 people have arrived so far in 2025 via small boats. The Rwanda plan was scrapped. It became mired in legal judgments. This new deal with France replaced it, offering that some who arrive can be sent back, while Britain accepts others from France who have family ties. Appealing, reasonable in theory. But practice has hit brick walls of law, human rights, courts. The model is fine until legal protections kick in. Experts warn that claims of trafficking, modern slavery, torture, or risk of destitution are not always last-minute fabrications. Often they are born of trauma, confusion, lack of access to legal advice, or delay in how the Home Office handles initial screenings. When someone is about to be removed, sometimes the reality of their situation only becomes known then. That forces them to make applications or claims at what looks like last minute, but often is the first moment their rights are really explained or available. The court's ruling in this case makes that clear. The judge determined the claim of human trafficking raises a serious issue to be tried. The government's task was to demonstrate that the Home Office carried out its investigatory duties lawfully. The removal was blocked to allow for that. What this means is that any removal under the One In, One Out deal may face legal scrutiny around whether due process was followed. Did the asylum seeker get access to legal advice? Were all the protections under modern slavery or trafficking law respected? Was the evidence properly assessed? And were they left destitute if removed? The government's response is fierce. Mahmood promises to appeal. She describes legal blocks as delaying tactics, saying that migrants only suddenly discover modern slavery claims when the plane is about to leave. She sees this as abuse of legal rights, undermining efforts to restore border control. This framing will resonate with parts of the public, especially groups concerned about immigration, national security, and fairness to citizens who feel their concerns are ignored. Opposition and human rights groups see a different picture. They warn that policies which demand speed and deterrence can cause chaos, injustice, and suffering. They argue that many people removed under these new schemes haven't been given proper opportunity to make their legal claims, or to see evidence, or to access legal support. The claim isn't always false, but often the legal infrastructure forcing these people into emergency legal claims is flawed. When systems move too fast, corners get cut, and courts end up intervening, as in this case. To understand how we came here, you need to look back at the legal frameworks the UK has built. The Illegal Migration Act 2023, The Nationality and Borders Act 2022, the now scrapped Rwanda scheme, and centuries of treaties and human rights obligations. The Illegal Migration Act tries to limit protection claims and tighten removal processes. The Nationality and Borders Act put powers in place to define who counts as a victim of modern slavery under narrow terms. But international law, the European Convention on Human Rights, components of UN treaties against torture, trafficking, non-refoulement, still apply. Courts have repeatedly ruled that no person should be deported if there is real risk of serious harm, torture, or slavery. These are not optional niceties, they are law. The government may dislike them, but legal blocks are coming from binding obligations. This struggle between government policy and legal rights is not new. In 2020, the Court of Appeal quashed a Home Office policy that permitted removal of migrants without access to justice, often with very short warning. That policy affected tens of thousands of cases. In that ruling, judges emphasized that access to the court is an absolute and inviolable right. You cannot remove someone if you don't allow their legal representation or their day in court. That precedent today looms large over any attempt to force through removals under the New Deal with France. But governments also argue that legal challenges are being used as delay tactics, that asylum systems are stretched, that public services, housing, border security are under pressure. If removals are constantly blocked in court, promises of firm borders risk becoming hollow slogans. Politically, Starmer AS government has staked part of its credibility on delivering on immigration control after criticism of Rwanda policy. Expectations high, public patience thin. For migrants, the stakes are life and death. A person wrongfully removed might have nowhere safe to go, suffer harm, or be re-trafficked. For the UK, every legal block, every injunction, every court judgment shapes the future of its border regime. If courts repeatedly halt removals, then the government must go back to Parliament, or revise laws, or define more rigid criteria for removal blocking claims. The tension between deterrent and duty grows sharper. Meanwhile, many legal scholars say the government must invest in earlier screening, detect trafficking or modern slavery claims sooner, provide legal support and advice as soon as possible, ensure transparency in decision-making. They warn that without these, more legal blocks will come and public confidence in the immigration system may erode, because in the end a system that promises both control and justice must deliver both, or it risks collapsing under its own contradictions. Then there's the public story, how media frames legal blocks, last-minute claims, modern slavery claims, vexatious. Words matter. They shape public perception. Is a claimant's trauma taken seriously in headlines or dismissed as abuse of process? How often does the government show individual stories of people who have genuine protection needs versus stories that fit political narratives? As of today, no migrant has yet been removed under the one-in, one-out scheme. Every scheduled flight so far has been canceled or blocked by court action. This alone tells you something. The ambitious policy is facing legal headwinds so strong they might force major adjustments or even abandonment. For Starmer, this is more than policy implementation. It is a battleground over principle, law, and identity. What's next? First, the appeal. The government will take this case further, likely to appeal the High Court's decision. That means delays, new arguments, legal scrutiny. Second, more court challenges. Any potential removal under the agreement can become a test case. Third, possible legislative changes. The government might try to redefine or restrict criteria for what counts as a trafficking or modern slavery claim, or tighten how evidence is presented. Fourth, public reaction. Supporters of migration control may push for stronger executive powers. Critics will demand accountability and human rights protections. The political stakes are high. In the coming days, keep your eye on whether removal flights actually begin. Keep watching for individual stories, what the court reveals in this case, and how similar cases may follow. Watch for changes or clarifications from the Home Office, how they handle interview timings, how they ensure legal advice, whether they pre-screen more rigorously. And watch for protests, legal briefs, human rights organizations speaking up, or possibly international institutions chastising the UK for breaches of international law. By the end of this week, millions will be watching. Will the government manage to start removals under one in, one out, or will courts repeatedly block them? Will this become law as intended, or a policy largely blocked by human rights protections? And what does this mean for the future? Is the UK moving toward a migration system defined first by deterrence and control, or one balanced with rights, justice, and human dignity? This is more than politics. It's legal power fighting legal power. It's about whether the most vulnerable get the chance to be heard, whether legal systems built to protect us can stand when governments push back, whether promises made in Parliament translate into reality or dissolve under challenge. And tonight, the UK government versus legal blocks on migrant removals isn't just a headline. It is a test of what kind of country Britain wants to be. Stay with us, because tomorrow may bring the ruling that reshapes everything.